The Indian Child Welfare Act was a act that was sponsored and introduced into law back in the early 70s. It finally was passed in 1978, along with the American Indian Religious Freedom Act and several other acts that were protecting our cultural and religious and traditional rights. But before 1978, it was a crime. You could be punished up to 2 years for actually speaking your own language, going to regular ceremony, doing a traditional marriage, going to a healing, and those type of things. The Indian Child Welfare Act came about because since the colonial times, our children have been modified by the colonial governments and the settlers that came here. They were traded. They were part of the slave trade. Some were even taken back to Europe as slaves. And then they came and basically ended up being in indentured service. Those children were impressed since the 1600s into these families. As time went by and the U.S. government fought, or the United States became a country, and the colonials before that had its relationship as a crown to the tribes, and then the colonial government to the tribes, and then the United States to the tribes. The use of children as commodification of our children came, which kind of came to a pinnacle in the removal period. A lot of the missionary churches ended up getting these kids that were left parentless on the Trail of Tears coming to Oklahoma, and other removals from other tribes. The late 1800s, late 19th centuries harrowed in these boarding schools like Haskell, Chilocco, and both in the United States and Canada, these boarding schools that were basically a failure, where they would cut the kids' hair off. They would be punished severely for speaking their own language. A lot of these kids died in the custody of these boarding homes and were put in mass graves on some of the places in the boarding school property. A lot of the boarding school property, of course, as you know, was indigenous land. And a lot of the new activism is to get these children's remains back to their people. In the late 60s, early 70s, and the 1950s, there was a termination era where Dallas and other metropolitan cities across the United States were relocation centers for Native people on the res to come and work, whatever. But in essence, they wanted to take as many people off the res and diminish those reservation lands even smaller because of the natural resources that are on those lands, and terminate tribes and have them matriculate and assimilate into all the broader American society, and then getting rid of the tribal identity. So a lot of these kids were adopted without hearings, without notice. In fact, some families would, church would have a vacation Bible school, let's say at Turn Falls, Oklahoma. They'd take the kids on a bus and they'd never come back. And they didn't know where they went. They'd been adopted out to non-Indian families. There were high rates of suicide with those kids because they knew that time and place was not right. They knew that there was something different about them. And so they did studies. And in these studies from the 50s until the act passed in 1978, they found the high rate of suicide. They found that it was genocidal in terms of tribal population and decimating these tribes. So they passed the act to set basically the rules with which a court must do any kind of an adoption proceeding or removal of a child from its parent into a foster care situation. And that is why this act was passed. Larissa, and also very important about the Indian Child Welfare Act, it has the most extensive legislative history of any act, with supporting data and testimony from a large variety of experts and Native peoples, tribal leaders. And when it was passed, it was meant to be implemented. There's been a number of cases since the passage of the act that have upheld the act and have identified that you don't have to, look like a 1950s movie and live in a teepee in order for the act to apply to your children.
And today with ICWA, is there any requirements, blood quantum, blood, Native American blood certificates and stuff like that to help a child?
The requirement to apply the act to a child is that there is an adoption or a removal proceeding. And to determine whether or not the act applies, the court has to ask the question, is this child eligible for enrollment in a federally recognized Indian tribe? Or is the child eligible for enrollment in a federally recognized Indian tribe? Each of the tribes set their own membership requirements, but in fact, if you are an enrolled member of a federal Indian tribe, then the act applies to any child that is an enrolled member of a federally recognized Indian tribe. Typically what that would be is a BIA card with a certificate of degree of Indian blood, or a CDIB card, as well as a tribal membership card. I don't think having the card is necessarily a requirement, because a child that is eligible to be enrolled is also protected by the Indian Child Welfare Act.
When a court identifies an Indian child, how do they make contact, or is it hard for the courts to make contact with the tribe?
Not at all. Many of the tribes have their own Indian Child Welfare Act officer and expert that will come and testify in cases. They're generally members of that tribe, or at least sometimes, you have parents that are, you could be a member of the other tribe, but you're enrolled in that tribe, but your mother or father is also of that tribe. The person that is the Indian Child Welfare social worker also is in the community, knows the foster parents that are qualified to take children as an Indian Child Welfare placement. And so it's not at all hard. The act requires the court to notify the tribe about the proceeding and allows the tribe to intervene. If the case is within the territorial boundaries of that tribe, then the tribal court generally takes that case, unless the tribe and the state have a memorandum agreement for the state judicial court system. If the tribe doesn't have a court system that can handle the case, that they would basically, in essence, do it on behalf of the tribe through the state court system. But in order to make sure that they comply with the act, the first thing, if they hear that the child is an Indian child, is to notify the tribe, and then they try to verify the child's rights to either become a tribal member or that they are enrolled as a tribal member, so that the act applies.
Sir, any recent updates, good or bad, from the recent decision from the Supreme Court?
Yes, the new case that came about was the Brackeen case. The Brackeen case for tribes was a case that was of great concern. When it first got filed in Texas, I said, oh my, this is going to be a very serious case for tribal people. At first, it didn't look as though it was, it was almost nonsensical. It was this act has been around for more than 40 years, and it's never had any constitutional scrutiny. Well, they got the right judge in the district court, and then they took this case, and the judge decided that it was unconstitutional at the trial level, that it imposed a commandeering of state officials, in the state of Texas, and then some other states joined in that lawsuit, and that it was unconstitutional because it was an illegal racial classification, an impermissible racial classification. It went through the system. The court in New Orleans, the Fifth Circuit of Appeals, initially decided, no, the act is constitutional, and reversed and remanded. Then they, oddly, I've never seen this happen, on their own motion, they decided to have an en banc hearing on it, which neither party had. And then it went to the U.S. Supreme Court. The Supreme Court came back with a lengthy opinion This opinion basically said it's not commandeering. The regulations that were passed by the BIA to advise the courts on how to apply the act so that an Indian child is properly protected under the act is not commandeering. And three, this is not a impermissible racial classification, because we as tribal citizens to a tribe are a political classification in that regard rather than a racial classification under the Morton versus Mancari case. That case said that there is preferential hiring, say for BIA, of a Navajo citizen to work at the Navajo reservation rather than a Cherokee citizen to work at the Navajo reservation, and then or a non-Indian to work at the Navajo reservation, because the person that they're hiring, being of that culture, tradition, history, has a better idea of how to serve that community. Therefore, as political members of a tribe, we are not a racial classification. Now, we have different tribal membership, which is Navajo, Choctaw, Cheyenne, Comanche, all over the field, 574 different tribes all over the United States, each distinct. But each of the tribes have protection under the Act, and the court is required to notify them if, in fact, a child qualifies as a member of either of those tribes as a political classification. Oddly, about this Brackeen case in Texas, there is a Texas Indian Child Welfare Act, 1995. A friend of mine, Paul Shunatona, and he's a Pawnee, and he's passed away. His another lady named Tish Tingle, whose brother is Tim Tingle, the Choctaw storyteller. They, along with myself as a student at that time, I was at the Cheyenne River under the Texas Indian Bar Association, promulgated a proposed Texas Indian Child Welfare Act that had the same language as the Federal Indian Child Welfare Act. So the Texas legislature passed it, notifying that we are political classifications, not impermissible racial classifications, and that the act applies as we request to federally recognized Indian tribes and children that go through the court system for an adoption or a removal and a child placement. The act does not apply to two parents divorcing and a child custody issue. A lot of people confuse that. However, a court can consider in the best interest of the child, the tribe's culture and traditions, and having access to that so that the child grows healthy.
It seems like the Supreme Court left a lot of things undone with the decision and left it as that. Why is that?
They were focused on the two primary issues. One of the Senator Aborsick, who was the guy who originally from South Dakota introduced the bill, had an amicus brief, and we focused on that legislative history that I talked about through the Lakota Law Project. The court focused primarily on whether the act was constitutional in an impermissible racial classification, and it was not. We're political citizens and political members of a political classification in a tribe. And that it's narrowly constructed towards protecting children. They really focused the decision on that realm of internal affairs of a tribal sovereignty rather than a tribal sovereignty in a broad sense. So I don't know if they're looking at that in terms of a limiting factor to tribal sovereignty, but they haven't spoke on that. So I'm hopeful that we use this to recognize more areas of tribal sovereignty that the federal government in our diplomatic relations between tribes and the federal government will realize. The second thing was this commandeering issue, which would also be, quote, unconstitutional to force a state and its agents to act under a federal act. Well, they said no, it was not an impermissible commandeering, as some other cases where state agents were required to act on a federal basis. And that area that they left unanswered was simply that what is the broad limits of our sovereignty? And I think it was probably good that they simply focused on the child welfare aspect of this sovereignty. However, it leaves, like you said, unanswered questions for the tribe in an area of sovereignty that we thought was very settled law for the last 50 years.
Right. The money that comes in for Indian Child Welfare Act, where does it come from? Who donates or who funds it?
Much of the funding comes from the Congressional Funding Acts for the Bureau of Indian Affairs. And then that funding goes to the various states, tribes, and some federal grants through nonprofits to provide services to these Indian children, like some of the adoption placement centers that get state funding that trickles down from the feds. And the way they've used some of those facilities has come under great scrutiny because of how they've used them, in essence, like a profit center, like, you know, and then they adopt these kids out to families that aren't native. And it's sort of what tribes and nonprofit advocates for tribal governments and people, like the National Indian Child Welfare Act Association, they look at this, and journalists like yourself analyze when there are problems in these privately funded facilities that are not, in essence, complying with the act. Most of that funding trickles down through the federal government. There are private grants for various services on the tribe, but again, most of the federal funding for the tribal ICWA advocate and or social worker and expert come from the federal government, as well as their own tribal funding. There is, in some of the states, state funding, because several of the states, and I won't go through the litany of lists, also have a state passed, like Texas did, Indian Child Welfare Act. That's why in this Brackeen case, it was so odd to see Texas doing it, because the Attorney General is already under the law of the Texas Indian Child Welfare Act and is supposed to move to uphold that law rather than attack the federal law that state law is based on. So states that also have those acts, and some of them that don't, also put funding into those facilities.
Right.
And I would say with the advent of casino income, tribes have actually had opportunities to fund healthcare, schools, Child Welfare Act advocates, and services, better services to our different tribal communities.
So there is a large funding for it, or a minimal funding requirement?
I would say there's not a minimum requirement. Typically, the federal funds are limited to what Congress appropriates.
That would be the Department of Interior.
Yes, and then the different tribes apply for, based on their financial need for those services funds. And in my opinion,
right,
I believe, I don't know all the numbers, but in my opinion, much of that area still is underfunded, even with the advent of private business funds, nonprofit funds, and the federal and state funding that comes to it. Now, in the private sector, these privately run facilities that are taking in foster kids, those are run, in essence, somewhat like a profit center,
right,
which is obviously very troubling to tribes, and how these children are adopted out and they receive funding from these adoptive parents to get at that. And some mothers are given funding to adopt a child out before the child is even born, that could be an Indian child. So that was areas where you as journalists have investigated and found kind of troubling issues as it relates to funding these type of private entities and adoption centers.
How often do you see children get taken by the courts because of technicality decisions?
Well, it depends on what you identify as technicalities. Oftentimes, the case involves parents that have been neglectful or abusive, and or have severe substance abuse and other problems, and where the point that it is the best interest of the child to remove that child from those parents or parent, and then the important category of that act is the underpinning plan of the act is to temporarily place them with either a tribal family extended of those parents or a tribal family of that tribe or an Indian tribe family that has closer associations with that tribe, let's say like the Chickasaw and the Choctaw, and then as the parents go through the process and get into a status where they're safe and can take care of those children again, to bring those children back to their biological parents. Sometimes that doesn't happen, but that is the goal of the act, to restore the family. And then, also with social services and child protective services to some degree, is to help those parents in that process. It's supposed to help, not create an impediment to those parents in that process. Sometimes there are mental health issues also associated with the parents that can't very well be monitored and controlled, such that the best interest of the child is to put the child back with those parents, so they can end up either with an extended member of their family, immediate family, or a further extended member of the family, then a tribal family or an Indian tribe family that's not part of the tribe. The goal of the act, though, is to try and restore it to the parent. But most of the time in these proceedings that I have seen, sometimes the court, not knowing a tribe's culture, a tribe's traditions, and just a family that is poor, can be misunderstood as neglect or abuse. Like, for example, as a kid, I ran around, and if I wore shoes in the summer, that was a strange thing. I generally ran around barefoot in the bottom of feet like leather, and I'd swim. And yes, I was muddy and dirty and stuff,
Right.
but I wasn't mistreated. A lot of people would see that and think that my parents weren't taking care of me because I was covered in dirt. But I spent little time not in the red dirt of Oklahoma my whole summer, or in the creek,
Right.
or a river or wherever, playing outside. And I come in at dark to eat, that was kind of the parenting of the 70s. So not having the problem with non-Indian courts, or courts that don't understand each tribe's traditions, culture, and parenting as a community, often create what you might call technicalities that they don't consider in removing a child from its family, rather than keeping a child in a family that's struggling, and instead providing services to that family and guidance to that family so that they can work together to maintain that child in the home. If you have somebody, unfortunately, that's a mental health or on drugs or alcohol to the point that it's unsafe for the child, then yes, the child can be removed. And I don't think I've ever met any tribal members that are against a non-Indian family being a part of the process in adopting the child. They simply won't, and our tribe simply won't, the court to follow the act in that process. And if they don't have qualified tribal placement, then they place it with a family that does have an interest in that child seeing its tribal heritage, its religion, its community involvement, its cultural activities, and having a connection with its extended family, as opposed to just taking the child and disappearing, and that child being lost to that tribe forever.
Right, so the biggest red flag is they don't know the traditions and culture of the child,
Absolutely.
and it becomes a big issue traditionally among Native Americans and the court system.
Yes, in assessing what is the best interest of the child, because that's what the court is considering. And under the Indian Child Welfare Act, placing the child with the tribe or the extended family or a tribal family, or even an Indian tribal family that may not be of that tribe is in the best interest of the child. Because even a family that is a tribe, let's say Chickasaw instead of Choctaw, and they have the Choctaw tribe, their culture and traditions are close enough that, and those families are close enough that they can engage that child with its own tribe. And that child will grow up in a home with tribal recognition, with tribal services, and have its proper identity, and not the confusion that they had before the act was put into law and applied.
Do you have any experience in foster care? Do you have a story that you can share with us?
I don't have any experience myself in foster care. The only experience I generally have is interacting with the professionals that are to provide services to our tribal people, and the different court systems that have had an Indian child welfare case in proceedings. I guess oddly in Oklahoma, they even had me testify as an expert regarding the Indian Child Welfare Act, and the court asked me to do so, although when you testify, you don't want to interfere in the purview of the court on the law. But the court in this particular case, and both the opposing lawyers, were interested in how the culture was important through the grandparents that wanted to adopt this particular child in that particular case, because the mother and the father both in essence had abandoned the child with neighbors because they had a drug problem, and they had an ongoing drug problem by the point that they weren't able to reunite that child with that family. So the grandparents did take it that were biologically the tribal member of that child. The court was very interested in how and why that was most important, because the court itself, being a state court, the judge was, even though it was in Oklahoma, was not very well acquainted with the importance of the act. And so that judge went bend over backwards to make sure he got as much information about the culture and why it was important before he made a decision in that case. And they did place that child with the Indian family in that. There were prospective non-Indian adoptive parents. And they were not bad people either, but the court had to make a decision on what was the best interest of the child in that case.
So there is a positive situation to this?
There is. And I have seen cases where after the court reviewed it, the only family that was available was a non-Indian family. And the non-Indian family had agreed, as part of adopting this child, to engage that child, because they lived in the community, with its tribal culture, and to be part of that child's life in the tribal culture, and them in fact living in that same community, wanted to be a part of that cultural experience too, even though they weren't enrolled members of the tribe. The trouble that I see is when they just want to take the child, and they want to create a new identity for a child based on their own family and values that completely isolate that child from its tribe, right, and the tribe from the child.
Are there levels of requirements for to be inside a foster care?
Yes, each state, and I would suspect the Bureau of Indian Affairs and the Department of Health and Human Services has a list of criteria that a foster home is supposed to meet. I don't personally know what each and every criterion is that they have to meet. But obviously, generally, the criteria is not the problem. It's having enough personnel to inspect and ensure that that criteria is being met by each of those foster home facilities is the problem, and that those foster home facilities are not secretive and only focused on profit, but actually focused on the health and welfare of the child, and have open doors in communication with tribes that are of Indian descent that are inside that foster care facility.
Yes, sir. There are 5 levels inside the criteria for the foster care.
Okay.
So from 1 through 5, 4 and 5 requires, like certain number of money and funds each day or month.
Yes.
So
Per child.
per child, right? So 4 and 5, the care for it, the funds for it is increased. That's when foster care usually gets really involved. But from 1 through 5, American Indians children are placed in 4 and 5 category automatically.
Without the consideration of the other criteria.
Yes, sir.
That is what the Indian Child Welfare Act is there to prevent. And hopefully, sadly, because of lack of cultural understanding for the tribe, the courts often are, they think they're doing the right thing, that they believe they're being unbiased, but they don't have enough information to make a rational choice about the best interests of the child without considering those things and without notifying the tribe often and without getting the tribe the tribes typically have much more limited funds than the state.
Right.
To get a tribal social worker to explain that component for the court to consider creates the problem of that jump, I think, because they automatically assume that the tribe can't provide the services that this private placement facility does. And so the importance of it is that the tribe is included in every proceeding or any placement at all. And while they may not have private placement services themselves that's run by the tribe, the private placement service can also use the tribe and its social worker to comply with the act. But having them not consider other options and only foster care placement without going through the steps that they should in order to place a child it's unlawful, but it's also just wrong in a human factor in considering that child.
In your opinion, would that be borderline child, what is it, what's that word I'm looking for? Child trafficking?
Well, certainly the adoption industry and Indian child placements in non-Indian homes, with it being, a $3 or $4 billion industry, has created naturally concern as to whether or not, our children are not meant to be put through puppy mills and placed out, The data that shows that those children are not going through the full criteria before being placed and then adopted out, and the data that shows that there's a higher level of trend with Native kids doing that, certainly, in my opinion, shows that there's some level of trafficking or there's some level of profit that is involved in placing those children like that and then adopting them out to these adoptive agencies and parents offering money in order to get the adoption of the child. Now, again, I haven't met anyone in the tribe or Native people that if the court and if the system follows the act, placing a child with a non-Indian family, as long as they meet, they've been through the criteria properly. But I know plenty of Indian families that are trying to adopt, and in court cases that I've been told about, have been involved in, where they got placed with a non-Indian child anyway. And that also, like you say, raises a red flag, in my opinion, about whether or not they're properly applying the act. The act is there. It won't do anything. It's the enforcement and application of the act.
Do you think Department of Interior should reinforce and reevaluate this portion of foster care requirements?
Well, in fact, the Bureau of Indian Affairs did with one of my colleagues when Kevin Washburn was the Undersecretary of Interior to the BIA. They promulgated a guideline for application of the Indian Child Welfare Act for all state courts. in conjunction with those BIA guidelines and rules, regulations, they offered assistance to these court systems. There is assistance, and many of the states supportive of the Indian Child Welfare Act have promulgated additional rules that complement those BIA rules and the statutory act so that they seamlessly work in their court system, so that the court system is not overlooking these things, and that the judges that have often no knowledge of Indian tribes can become aware and be fair and unbiased in their application of the act.
How many cases do you see a year in your experience in your profession?
With the Indian Child Welfare Act, I would say I get probably at least 10 to 15 calls a year about issues involving a court proceeding and questions about it. I have investigated some. I typically, I'm not a family attorney, so I don't represent one or the other party in a adoption proceeding, but I have advised tribes, and I have worked with the social services people that of different tribes for the Indian Child Welfare Act to assure that the court has notified the tribe. The tribal attorney in charge has been able to respond to it. Some of the times I have had cases where people claim that the child is Indian, and after a due diligence investigation, the child is not eligible for enrollment for one reason or another. Either the ancestor never got on the Dawes roll, as you might say, in Oklahoma, or out in another tribe did not meet the criterion that the tribe is set to become a tribal citizen and a member of the tribe. Sometimes that membership is based on blood quantum. Sometimes it's based merely on descendancy. So blood quantum that was designed to diminish tribal populations and in essence diminish the number of tribal citizens and ultimately terminate the tribe. The blood quantum was created a federal construct to diminish our numbers and as a tribe. But and they sold it to tribes often as, oh, you're keeping your bloodline pure and all of that. But in modern times, it's hard to find tribal members that haven't intermarried with a non-member another tribe, or a non-Indian of some sort. And that doesn't make them any less Indian in their heart. So tribes having sovereignty to determine what their membership is very important, but trying to diminish the tribes so that this act doesn't apply to children down the line, I think is going to be very harmful, in a sense that not having the act was harmful before the passage of the act.
How many Indian children are taken from the courts and away from the tribes a year, in your opinion?
I do not know those particular numbers. It would be based on each state where proceedings are going involving Indian children. Each case is different. I guess where the greatest concern would be is in counties and courts and state court, where it's more rural and they don't have an interaction with tribal governments. They don't have a lot of native people in their community, and they come from an ethnocentric view of what is the best interest of the child, as opposed to looking at the culture, the traditions, the history, the religious aspects, and the social structure of a tribe, of that child, so that they can make a decision that is in the best interest of the child. And under the act, that is to apply the criteria and the requirements of the law under the act to placement of the child.
Yes, sir. Do you have any of your cases that has been like under media attention?
The one case that I was tangentially involved in was the case of the Cherokee child that is known as Baby Veronica. And it came out of South Carolina. And the state courts all passed that the Indian Child Welfare Act applied. It went to the Circuit Appeals Court, State Supreme Court. They all said that the Indian Child Welfare Act applied. The case involved a young lady that took money and gave her baby over to an adopted couple that couldn't adopt a child otherwise because there was some criminal background and one of the parents passed. And they paid the woman around $100,000, and as best as I can remember, and in my opinion, that father, the putative father, was an enrolled Cherokee member, and he was deployed to Iraq, and there was a text back and forth between he and the mother, and that text was used as a waiver of his rights, even though normal waivers involved, notarization and proper notice and all of that. Ultimately, that child got placed with a non-Indian family by Supreme Court opinion, and the child was taken from the Cherokee family and the biological Cherokee father and placed with the non-Indian family. I was consulted in that case simply as you're asking me questions about the application of the act. It, in my opinion, looked like the state courts had gotten it all right in South Carolina, and then ultimately they reversed those decisions at the Supreme Court. They obviously had more information than I in the case, other than me just simply being an opining, an opinion commentator about that law. So the Supreme Court made its decision and its stance. That created a very high level of concern among tribes as to the application of this act, and that they narrowly made that decision not to find that the act applied, and that the act was not important in placement of the child, where the tribes differed with the Supreme Court's opinion.
Do you think we need more lawyers or attorneys to help with the Indian Child Welfare Act?
I would agree that we do. I know that the gaming industry is focused on the Indian Child Welfare Act is the weak link in the armor of tribe sovereignty. And the gaming and the energy industry has poured a lot of money in challenging Indian Child Welfare Act on a constitutional basis through the Brackeen, as well as the Goldwater Institute, which are extremely conservative think tanks. And the reason is because since 1885, the basis of federal statutory is on a trust relationship of Congress to Indian tribes under the Commerce Clause. If they can find that that's unconstitutional and tribes are not able to put as much money into the Indian Child Welfare Act and enforcement of the Indian Child Welfare Act, if that is found unconstitutional under the Indian Child Welfare Act, which they've said is not, then they can attack the Indian Gaming Act. They can attack any federal statutory passed since 1885 and claim that it's not a constitutionally supported act that oftentimes protects tribes from problems that the Indian Child Welfare Act protects it. So that has been their legal goal. Tribes, on the other hand, are trying to prevent it. Those for-profit interests failed with the Indian Gaming Act, so that's why they focused their attention on the Indian Child Welfare Act. Native people represent less than 1% of 1% of the entire population in terms of legal professionals. Tribes don't have great resources often. More tribes have less resources, and a few tribes do have revenue to assist in Indian Child Welfare Act. We do need more Native attorneys. We need more Native attorneys that are also involved across the board, across the United States, in being involved not only in tribal government, but tribal affairs, which also include the Indian Child Welfare Act on diplomatic relations between states, tribes, and the federal government. And by doing so, we can ensure theories of equality with everybody. as opposed to only the monetarily wealthy and powerful being able to determine and dictate what happens with our tribes.
On a separate question, child support on Indian reservations, how much do they get involved, like legal jurisdiction, red tape?
Well, child support is a completely separate issue from the Indian Child Welfare Act, and whether a tribe is placed with an Indian family or a non-Indian family. Child support is generally between a husband and a wife, or a father and a mother that are going apart, and one gets custody of the child, and the other would owe the custodial parent child support. Child support orders are enforced in tribal courts, and child support orders that come out of a tribal court are enforced under full faith and credit by state courts. Is there problems sometimes in that? Yes, but those courts typically seem to work them out. Support, on another hand, to private foster facilities is a different matter, if that's what you're referring to.
Yes, sir. Can you tell me a little bit about yourself, your education, your background, sir?
Well, my mother was relocated to Richardson, Texas, and she was a school teacher first in a segregated black school here in Richardson, Texas, with the Richardson Independent School District. It later desegregated, and I grew up in North Texas, Richardson, Dallas area. I went to high school and graduated. I then went to undergraduate school at Southern Methodist University and got 2 degrees, one of them in anthropology and another Bachelor of Science in economics, finance. I then went out in the workforce, and because my granddad is a Choctaw, and I saw him as an adult struggle in my childhood with discrimination as well as what it was to be an Indian. I never understood as a kid why we always had to go to a ceremony or something very secretively, and I didn't understand that till I went to law school, because it was a crime. You could be punished for actually going to a traditional ceremony, and if I spoke Choctaw, they'd say nish nish, don't do that, and that was again because it was a crime, but also they just didn't want to be discriminated against, in the 60s and the 70s during that era. I then went to the University of Iowa Law School and had the privilege of getting to work as a fellow to a Professor S. James Jim Anaya, who is the international indigenous rights expert in the United States. He's now the dean of the Colorado Law School. And I was also a fellow at the University of Iowa Law School to another professor, as Robert N. Clinton, who rewrote and reissued and edited Felix Cohen's Handbook on Indian Law, which is actually right here. And it is the seminal handbook on Native American treatises, and that is the Indian Child Welfare Act.
Yes, sir.
As well as other federal statutory. And I had the great privilege of helping him update that book, as well as his own case book on federal Indian law. And the other thing about it is I got to go to work for Bernalillo County, and I focused on indigenous rights as a prosecutor, as a student prosecutor at Bernalillo County, in substance abuse, family violence, and issues as the county offices providing services to the urban Indian population in Albuquerque. I then got out of law school, took a bar exam, and then I went to work for the Cheyenne River Sioux Nation and the Cheyenne River Indian Reservation up in Eagle Butte, South Dakota. And I worked there for several years as a tribal prosecutor and attorney, and had some really good cases. I prosecuted the first murder case since U.S. versus Crow Dog and the passage of the Federal Major Crimes Act in 1885. And then I prosecuted another one where the federal government had declined prosecution in those cases. I picked them up and tried them in tribal court because I felt like it was important to the tribe to ensure that all of our tribal citizens are safe. and that nothing fell through the cracks. And we instituted what I called the Healthy Nations Project. That was between tribal administration and schools, private entities in the community to help our youth break a cycle of trauma and hopelessness and help get them out and into schools, into colleges, and education so they could bring that knowledge back to the reservation and grow our tribes in a sustainable way. I've been in private practice here. I've been hired by some tribes. I've represented some civil rights issues with tribal members. One young man who was Kiowa that the school district wanted to cut his hair off, and as a Plains Indian, as a member of the Kiowa Nation, that is a religious thing and a cultural thing that represents the health of that child, and you don't cut your hair off unless you're in mourning for a loved one.
Right.
And I worked with the school district, didn't ultimately have to file a lawsuit, and they recognized that. Although the child was kind of singled out because of the hair, Texas has since passed a statute that is gender neutral about hair length, but some of the schools still are trying to impose this grooming code that is not gender neutral. And they want a letter or something from a tribal members or tribal chief stating that our chairman that says that the child is a member of the tribe, rather than just simply, the tribal membership card. I have represented some kids on having eagle feathers on their graduation cap, and they took the eagle feather off the graduation cap. I assisted in the family in that particular case. And then just locally, some of the Indians, advising tribal social workers and working with families to consult in how they can better get a court to apply the Indian Child Welfare Act. I like being very active in our urban intertribal community and assisting Native families and in the community so that they can live good and healthy lives, and we have a vibrant Native American community in the DFW Metroplex.
Thank you very much, sir.